speechless. We're glad to have you here. We're live. Well, we're not live. This is a pre-recorded program today, but we are from the St. Paul Neighborhood Network, SPNN, and the show will be dealing with two press conferences that took place earlier this year. Now, as some of you know, I haven't been able to do my show for a while, but now we got it up and going here at SPNN. And since I hadn't done it for a while, I got a whole lot of backlog video. And the question may be, is this out-of-date video? Well, no, it's not, because a lot of these things last quite a while, especially court cases. They take a long time to process and are still being processed as we speak. But we have two press conferences I want to show you. One is a parental rights case relating to Anmarie, boy, I forgot the last name. I didn't write it down. You're going to see it, you're going to hear it enough. But it's amazing how the state can just come in and take over your life and not tell you, and take over your children's life and not tell you. And that's what's happened here. I think you'll find it a fascinating press conference. Hopefully it will stir you to call your state senators and state reps and say, hey, you have a responsibility to go and punish. And what I mean by punish, or discipline, or censure, or fire these employees who have violated a parent's constitutional rights. It is unbelievable that this takes place in Minnesota. And it's unbelievable that these school districts, these counties, the social services will justify their decisions based on because they want to. I mean, that's all they have. We just wanted to do this. We just wanted to take away these parental rights because we wanted to. So that's my opinion on that. The next press conference will be about a restraining order against the Secretary of State, saying, Secretary of State, you got to make sure that felons, that people under guardianship, that illegal citizens can't vote. It's in our Constitution. They can't vote, and you have to make sure that that happens. So our restraining order is for you to make sure that they don't get to vote. And so we'll discuss these things as the videos go on. But let's, first video is about 24 minutes. I may break in, I may not. They tell the story very well. But let's hear let's hear this press conference on parental rights.
I'll just make my statement brief and clear. Today in a hearing with Judge Magnuson, I challenged in federal court the authority of state agencies and private businesses to deprive me of my parental 14th Amendment civil rights. My minor son has received health services, narcotic drugs, hormonal drugs, welfare, housing, food stamps, and a driver's license without my knowledge or my consent. The school district is also treating my son as an adult. I believe these actions violate my constitutional due process rights, and because no court has ever approved a legal emancipation for him. I believe this is an abuse of my rights and the rights of all Minnesota parents in similar situations. I have a right and a responsibility to care for my child, for both his physical and emotional health and safety. But these agencies and services have denied me that right. In this hearing, I have presented my case and asked the court to declare that my due process rights under the 14th Amendment of the Constitution have been violated. I have asked the court to restore my full parental rights. I'm hopeful these proceedings will help all parents and all families in Minnesota maintain the constitutionally protected rights that are in the best interest of their children, all children. As I have stated many times before, I am firmly committed to what is best for my son, for all of my children. I am his mother. He is and always will be welcome in our home. We are a blended family of 8. My son has 3 older siblings and 3 younger, which still live in our home. 1 sibling is deceased. I love him beyond words, and our entire family care and love him very, very deeply about both his well-being, physical, mental, emotional, and every other aspect of it. So I thank you for being here today and allowing me to speak.
Thank you. My name is Erick Kaardal, and it's a historic day in the U.S. District Court today. A parent was able to argue in court that her procedural due process rights were violated in the sense her rights to control her child's medical care and other decision-making were terminated without due process. And so this is significant that a county, the school district, and 2 huge and significant medical service providers are terminating parental rights without notice to parents. I mean, how would you feel as a parent if your 17, 16, 15, 14-year-old child were making school decisions on their own, making medical care decisions on their own, getting general assistance on their own? I mean, what's happened? The Minnesota State Legislature has preserved the emancipation age at 18, but now all these agencies are running all over the place emancipating children. It's chaos. Fortunately, the U.S. Constitution, which the U.S. District Court is here to defend, has another view of it, and that is the U.S. Constitution always applies to protect parental rights before they're terminated. The state legislature has recognized that in the areas of marital dissolution, paternity, child protection, but yet in emancipation there's this gaping hole. The teenagers are on the loose because the state agencies aren't adhering to the U.S. Constitution, and that's got to change, and we're here to change that. Now, for Anmarie and her child, this is a tragic case, and we never wanted it to get to this point. But the procedural due process claim is based on the idea that when these state agencies terminate parental rights without notice, the state court doesn't have a process to challenge them. There's no statute, no common law cause of action. So when the state court doesn't provide a remedy for a violation of a federal right, then you have to come to federal court. So we're here in federal court not because we want to be, it's because we have to be. And here, the state agencies, the county, the school district, these 2 medical agencies are so clearly violating parental rights, and they just don't care. I mean, it's not like when I do this research and I go down all these tunnels and labyrinths and I find the law that it's private and hidden. It's public. If Fairview and Park Nicollet cared about parents, they would find the same law I found and know in a common sense way that if you're going to terminate the parental rights regarding the health care of a child, you should send a letter, at least after the fact, to the parent. It's constitutionally required. Of course it is. Every parent knows that. And every U.S. District Court knows that. The hearing today before Judge Magnuson, who's a very experienced, well-respected judge, went very well. The issues are complex. Judge Magnuson asked very good and concise questions, and we thought we answered them well. We don't know how the decision will go one way or the other, but with respect to where we're sitting, these are clear constitutional violations that need to be remedied by the court, and they reflect very poorly on our government agencies in Minnesota with respect to defending parental rights. Any questions?
If the judge does decide in your favor, what happens exactly?
Well, it's a huge decision. It'll have reverberations through the whole system. Basically, what it is a rejection of these elite institutions, the county, the school district, and the medical care providers in their narrow interpretation of the Constitution. And all the medical care providers in the state and the others will have to review their policies, and then they'll hopefully adopt policies where if they grant a teenager the right to make all these decisions, that they send a letter to the parent saying, well, you can contest this, but this is what we've done. And so it'd have a huge impact. Eventually, the state legislature is going to have to get on the ball, and when it authorizes executive agencies or counties or school districts or medical service providers to emancipate children for decision making, that they have to provide a process for the parents to challenge them.
You said in court that your client is not opposed to a sex change in this situation?
She's opposed to sex change surgery generally, but with respect to her child, she just wants to have a part of that process, and they would make that decision jointly. So in entering that discussion, she would have an open mind. It's very difficult with the gender dysphoria. It's a psychological condition, and the only thing we can be assured of is that Anmarie's involvement in her child's process would make for a better decision-making process. After all, if there's no parent involved, who's making the decision with the child? Well, it's either the government or the medical service provider, and we know as a general matter that that's less ideal than having the parent involved.
And for the last 2 years, she's had no contact with her son?
No, the relationship has been actually good. The affidavits show that they have a lot of communications. When E moved out with the father, it was with the consent of Anmarie, and they continue to communicate, go on vacations together. There's some financial support and so forth, but there are these areas of disagreement, quite typical of parent-teenager relationships. But what was strange here was with this letter of emancipation put out by the legal aid clinic, that all the state agencies just said, no parental rights. And that meant that she couldn't get any information about her child. She would get the information from the child because they would talk even daily about things. But it wasn't the same because the power relationship changed. And any parent of a teenager would know that that's a significant thing. In fact, Anmarie shared that in some of the conversations, she's told her son that he's getting bad legal advice. And his response kind of jokingly is, well, I've been winning. So that's the sort of sophistication teenagers have. But we've decided they're not mature enough in Minnesota until they're 18 to be free of sort of parental control. And so how do we terminate parental rights prior to the minor child becoming 18? And we have to do it with process. It's another debate whether we should lower the emancipation age to 17 or 16. Set that aside. This case is about when we authorize someone to make the decision whether one minor is exempt from the emancipation age of 18, what kind of process is there? And it just can't be the school district, the medical service providers, and the county saying emancipated without even telling the parent. It's just wrong. It speaks poorly for us as a people that our government is doing this so badly. And so what we need to do is start here, get this decision, work with the state legislature, mandate better processes, and then mostly tell Park Nicollet and Fairview that they can't do this to parents. We've gotten phone calls from parents who get the bill, but they don't know what the minor child has gotten for medical services. Well, what kind of a system is that? We need a system that's fair to the parents and it's fair to the child, and we've gone way overboard on being conducive to the child emancipating and terminating the parental rights.
What happens when the child turns 18? What's the next step there?
Right, in Minnesota, when a child turns 18, they get the full panoply of parental of adult rights, so completely emancipated. So at 18, they're an adult. And so this is a great question because, well, okay, if the state legislature reduced the emancipation age to 17, then we wouldn't have a case because he'd have all those rights. So when the state legislature makes these exceptions on a case-by-case basis and authorizes someone else to make the decision, then we need to have all the notice rights and opportunity to be heard for the parents. But we know this because in the marital dissolution, paternity, and in the child protection areas, we already have that. There are paragraphs and pages of due process rights for parents. Parents are given once, twice, 3 times notice, opportunities to be heard before the rights are terminated. But here for Ms. Calgaro, she got none of the notice that a parent would receive in those different proceedings because it was emancipation. And so how does that work? Well, it doesn't work because we have a U.S. Constitution that protects those fundamental rights from termination without due process. And so Minnesota gets an A+ in the areas of marital dissolution, paternity and child protection on protecting parental rights and the notice to be heard and so forth. But in the emancipation area, it fails, and it fails miserably. And this is happening all over the state. And what's most disconcerting for us is you have these medical service providers in counties and school districts in on it. Well, these are our agencies. These are our clinics. Why would they be so inattentive to parental rights? And that's a question we have to ask about ourselves. And so this case is just the beginning of a reform in the emancipation area. And Child Protection League is here, and they're working with Representative Glenn Grunhagen and some state senators, and they're going to put together some remedial legislation. Hopefully they'll restore the balance so that we have parents getting notice and opportunity to be heard before these agencies terminate the parental rights.
Do you feel that the judge talked a lot about the connection and the relationship between the parent and the child. Do you feel that, does Ms. Calgaro fear that by going through the courts and doing this process that it's going to push her child further away from her and that she's not going to have the opportunity once a child is 18 to repair that?
Yes, and that's a complex decision made by Anmarie as part of the process. And that was part of the reason why I was in the courtroom and I publicly apologized to Anmarie because the nature of procedural due process arguments are very technical and very legal. And so I turned this parent-child relationship into sort of a legal thing. And it's unfortunate, but I apologize. And the point is that we're right and the government's wrong. And the only way you hold the government accountable, particularly with government attorneys who are willing to disassemble constitutional rights, disassemble state statutes, and disassemble common law, as we saw in the court today, is to be very precise and legally precise. So you can't let the government escape. You've got them in a legal corner here because that U.S. Constitution says that parental rights are fundamental rights that can't be terminated without due process. And they came into the courtroom and said everything but that. And they, in this case, when we filed it, they came to it. They came right to it. They said, we are not going to give her notice even after the fact. So we decided you didn't have parental rights in this subject area, and we're not going to give you notice even after we took it. So I expected some sort of after-the-fact process, but no, they stuck to their guns. You would think that there are parents and children in Minnesota, that we're all just sort of persons. And so Anmarie Calgaro is saying, no, I'm not a person with respect to my child. I'm a mother, I'm a parent, and I have rights, and the U.S. Constitution protects those rights. And then every step of the way, the government attorneys and the medical service provider attorneys have argued, no, those rights aren't important, or that's not important there. And it just speaks to us, right? It speaks to us. We've gotten really in a tough spot with respect to parental rights, where these huge and significant institutions won't do the research to figure out something so common sense as, if you let the kid make the medical decisions on his own, you got to tell the parent. What's wrong with that?
And just to be clear, everybody the three agencies decided that he was emancipated based on this letter from Legal Aid that the judge in there kind of seemed to indicate didn't have any legal weight at all. Am I right?
That's right. The Midwest Legal Aid Clinic was involved in this and gave the initial legal advice to the minor child. And remember, under Minnesota law, a minor child can't even contract for legal services, can't file a lawsuit, can't do any of those things. But anyway, he got all this free legal advice, and the one document said, you're emancipated. And then all these state agencies and medical service providers made similar decisions. He's emancipated. So you look at it all together, and he's emancipated, yet the Minnesota judicial website says if a teenager wants to become emancipated, they file a petition for emancipation, and the court determines on a case-by-case basis whether the child's emancipated. And the court has the power to make that emancipation decision full, partial, temporary, or conditional in the best interest of the child. And we're so accustomed to this because the court serves the same role in the marital dissolution, paternity, and child protection areas. And so we trust judges to do that. I mean, you might have a view on judges, but one thing as people, we trust judges to make that decision in the best interest of the child. You know what happens often? The child acts as sort of a parent. And that's why I think when I read those opinions, I said, well, that's really cute. So the court has the power to give the adult rights to the teenager, but conditionally. Fantastic, that's parenting, right? And do you think the medical service providers here, Particulate and Fairview, have that same sensitivity a judge would have? Does the county have that same sensitivity? No, they don't even give notice to the parents. So when you look at this as we are, and that is you put the government action under a microscope, you would say that these agencies don't care about the parent-child relationship. And that's a travesty. I mean,
Is it the state or the county that's actually paying for the medical services?
The state, through MinShare, is paying for that. The county is providing general assistance, so it's all kind of connected. And I do want to mention that, too, that the county is relying on a statute that says general assistance shall be provided to a minor child who's been legally emancipated. So for us, legally emancipated would mean a court order. But the county's saying, no, we don't need a court order because we make legal decisions and we'll just do it. Well, if they're going to take that on themselves, then they have to provide the due process that will be afforded in a court proceeding, and they don't do that either. So they get the statute wrong, and then they administer the statute according to their incorrect interpretation. They don't provide the notice to the parent before terminating the rights, so it's a double wrong.
And the defense in there said that Anmarie had not contacted the school district about his grades or being involved. Do you want to speak to that?
I can speak to it. The issue there is that she got the Jupiter grades or whatever it's called, notice that she wasn't going to get information on the minor child, the grades. And then she went to the office and she was told the reason was he was emancipated. And they're kind of saying, well, you didn't ask specifically for the information, but she did. She asked for everything. And once she heard that they were considering him emancipated, they were saying, you don't have any rights. So she knew what the answer would be. So she was asking for the grades, and she was asking for everything. And they said, you don't get anything because he's emancipated.
Yet there is a relationship here still between
Right?
Anmarie and her
Anmarie, do you
son.
want to answer the real? If you want to answer.
What's the question?
So there is it sounds like there's a fairly decent relationship between you and your son still.
Can I speak on how the attorneys advised him?
Sure. The attorneys have advised E not to communicate with the mother. We think that's insensitive in a name, but Anmarie has heard.
Yeah, we were speaking often. I mean, so up to sometimes 3 times a day. We'd come home and there he was in our kitchen eating, and we're like, oh, hey, you know. And the 3 younger children, I've just told them that, you know, this is your sibling, and that you show him unconditional love just as we would each other, and that it's so important, especially at such a young age. I like when the judge said that, you know, when I was 16, I thought my dad was really stupid, and my mom and my daughter are here today, and I have to say that, you know, I thought the same thing too, and you know, my child has felt that about us, you know, like we don't know what's best for him, and I believe we do. I look back now and I'm like, wow, my mom did know what was best for me then, you know, but I didn't want to hear her words.
Because you have such a strong relationship with your son now, what do you think your relationship will be like, and will you continue after this, after the judge makes his decision?
Well, I have to be honest, since this has taken place, since he got with his lawyers have advised him not to speak with his entire family.
How long's that been?
Since the last, well, about a week after the last the press conference when you were all there, yeah. We did have some exchanging of phone calls. We bought him a bunch of gifts for Christmas, and I got a hold of one of his friends and asked her, because I'd been trying to reach him. He's not speaking to his dad, he's not speaking to anybody. And so I asked, could you please is there a way that you could get him these gifts from us? You know, he doesn't have, you know, and he told her, well, I'm not allowed to talk to them. She's like, well, I'll be the mediator, I'll bring you the gifts. And so they met up in a Walmart parking lot, and she gave him all the gifts. And so,
How difficult have these last few months been?
oh, I don't know that there are words that can describe. I miss my family being together, as anybody can imagine. We went through a lot of tragedy in our life. I just never expected this. I miss my family.
So it sounds like as a teenager in your relationship, just so I have an understanding, he's saying, I love you, but I want to do what I want to do.
I'm gonna do what I'm gonna do, and you can't tell me otherwise. And I really just wanted to, let's do I'm a researcher. I'm like adamant, whether it's about vaccinations, whether it's about education, I'm researching it because I really am in the best interest of all my children. And I wanted to be a part of this so that I could say, let's really look into the side effects of the things that they're, prescribing you. Let's look into what, let's look at other testimonies of people who are facing similar circumstances. Let's dig into the information. Let's not make hasty decisions. Let's just take our time on this. There's a lot of statistics out there. I'll say that the one that never gets put out there is that, and it's in the 80th percentile for children who go through gender identity confusion, or however you want to. I am sorry for not being politically correct, but that if they make it through puberty and into adult life, they come out just fine, most of them. I mean, and I'm not pushing. I just wanted him to give it time. Let's talk about this. Let's research, and let's not make hasty decisions. I think any parent would want that for their children. So,
I just want to mention one thing that because I was involved in a pre-litigation process, and that I don't think any of this lack of communication would have occurred if there had been a good process. So if E, the minor child, had petitioned in state court, and Anmarie had gotten notice, and then there had been this process, and then the court made its emancipation decision, they would still be communicating. So the issue here is, why wouldn't we have a good process in Minnesota where both the child and the parent understand what's going to happen with respect to emancipation, full notice and opportunity to be heard? And we do this in all these other subject areas, and here we don't. And so, Anmarie's kind of like a legal orphan here. She's a parent, but she has no rights. And we are all accustomed to parents having rights. We even assume that parents have, it's like the air we breathe. We assume parents have rights that can't be terminated without notice. But here we have a legal orphan because no one's protecting her rights, not the state legislature, not the county, not the school district, not the medical service providers. And I've gone that next step in saying, why are they so inattentive to parental rights? What does it say about these organizations that they simply don't care about a mother's relationship to a child to send a letter saying we made this decision, provide an opportunity to come in and talk to us about it, and maybe we'll change our mind. So thank you so much.
Judge Magnuson seemed to really not want this case in his courtroom. He just seemed to imply it over and over again. There should have been couldn't there be another process? There is, the standing issue.
Well, this happens a lot. I've litigated over 100 cases against various government organizations, and everyone wants the government to succeed, but when the government falls short, the most important role of the court is to hold the government accountable to the rule of law. I can't think of anything more important. Now, someone will tell me, oh, Eric, it's putting criminals in jail. No. The most important role of the court is to make sure that our very powerful government follows the law. And this is one of those cases where, and I mentioned that I don't think the government here has been doing anything that's menacing, but it's really a mess. It's just a colossal mess. And did I create these facts? No. I just came to the facts, and it exposed this huge mess. And a huge legal mess, and your state legislature, your counties, your school districts, your healthcare providers are all involved in it. And it's all in contradiction of the U.S. Constitution. Now, one might say, who cares? Well, that's what they're saying. I care, Anmarie cares, and everyone else should care because the defendants are constitutionally wrong. Thank you so much.
Oh, I'll put my mic on here. Fascinating press conference, to say the least. You need to watch that over and over again. There's so many intimate aspects and so many details of that press conference that explains our family law. I just find it interesting that part of this discussion in the courtroom was the state took away and the parental rights. The child was emancipated without notice to the parents, and there is no legal way to reverse that emancipation. Where a parent can go and challenge, no, your emancipation was wrong. There's no law that allows that to happen, because the assumption is law is that you got notice, And here's the thing, and I think what Erick Kaardal was also saying there and said was that, the law assumes you get notice. The law assumes that the government follows the right process that's laid out when your rights are going to be taken away. But when the government doesn't follow that process, what remedy do you have once a child's been emancipated? There isn't anything in law that reverses an emancipation. And so that's why he's saying the legislature needs to fix this. They need to write some laws, but it's also why the federal government and why Anmarie needs to sue and did sue the federal government, in the federal courts against the counties because of violation of her parental rights and violation of due process. So it's a fascinating case. It's ongoing, and we still haven't heard. I think that was filmed in January. Still haven't heard from the courts yet as to how they're going to decide. I am not, the court court is kind of saying we're not persons. We're just all, at least this is how the county, the St. Louis County, the U.S. Legal Aid Society is all saying we're all one. There's no such thing as a mother, a father, a parent, child. Those relationships don't exist. We're just all homogenized or whatever. We're just there, and the state can do whatever they want with us. So it's a good question to answer for yourself is who owns you? What do you own? And the real answer, as Minnesota has been applying it, is the state owns you. And the state can take whatever they want from you at any time. They just have to have a pretense of a legal reason to do that. Now, in this case of Anmarie Calgaro's son, the state said, we're not going to follow due process. We're just going to do it. You see, and that's a lot of the state's mindset, a lot of people's mindset, especially when they become legislators or judges or work in the executive branch. They're the parent. They control every aspect of your life, and they'll take away your property. And the whole question is, are you getting your due process? Well, here's the one thing bad about the courts, because we have a lack of accountability in our court system, is that Anmarie Calgaro could have received her due process rights. Let's say she did, all the way through. A judge, based on their own discretion, could go and say, even though you have your parental rights, I'm going to say you don't, and then just make something up as to say why they should be taken away. They can do that, and then you go to the appellate court and, well, yeah, all your due process is right. You had a court hearing, everybody was noticed, and the judge has discretion as to how to make this decision. It doesn't matter whether the facts are not facts, but information is made up incorrectly. We're going to do what we want to do. Okay. We'll follow up on this case more often, but this is important. This is why we need to pass a U.S. constitutional amendment about parental rights, and let's see the video clip on this.
There's one thing we can all agree on. When it comes to raising children, family is better than the government. Sadly, in 1927, the Supreme Court denied parental rights to parents with disabilities, a precedent continuing to this day. African American parents also see their parental rights taken away at an unequal rate compared to other parents. The U.S. Accountability Office has attributed this in part to racial bias. In 2000, the Supreme Court's decision in Troxel took away the protection parental rights used to have as a fundamental right. As a result, parents of all backgrounds are seeing their rights slowly slipping away. Imagine your child being taken away from you simply because you wanted a second opinion on a medical procedure. Or being told you cannot view library information for your children, including the titles of books that are accumulating late fees. Or being refused access to your 13-year-old's grades without your child's consent. These are real situations happening to real people. Whether Republican, Democrat, or Independent, it's time to unite and act to protect children by preserving parental rights. It's an issue that matters to us all. Show your support by signing the petition. Then share this video with at least 5 friends. Together we can unite and protect children by empowering parents.
Yeah. Call your U.S. rep and senator and get them to sign on to this constitutional amendment. And even in Minnesota, there's no reason we can't pass some statutes or a constitutional amendment that would support parental rights here. All right, we're going to change subject here, and I do have another video in the control room. Secretary of State, SOS, should be just the next one down. And there was a press conference held a number of citizens sued the Secretary of State to get the Secretary of State to make sure that felons, illegal immigrants, and guardians could not vote, and to establish that process to make sure that it didn't happen. That's what our Constitution says. Of course, the Secretary of State has been fighting that, but we're going to watch this press conference and come back and make some comments after that. So let's watch this.
1, 2, 3, go. Good afternoon. My name is Greg Buck, and I am here to summarize the issues for the hearings that are about to take place in about an hour upstairs. This afternoon, we're asking a Hennepin County judge to consider asking for a restraining order based on the following facts. We believe that the Secretary of State, through his election judge guide, has directed election judges to provide ballots to ineligible voters. We believe that the Secretary of State knows that he's doing this, and we're simply asking the court to tell the Secretary of State to stop. We're trying to keep it easy. Now, for a little bit more in-depth discussion of the legal issues involved, I'd like to introduce Erick Kaardal, who will speak to the legal issues. Can you say and spell your name, please?
Yes, my name is Erick Kaardal, E-R-I-C-K-K-A-A-R-D-A-L, and I'm the lawyer representing the Minnesota Voters Alliance in Ramsey County District Court today. And my clients are 3 election judges and the Minnesota Voters Alliance, and then a former candidate, Kirk Stensrud. And these clients are seeking a very narrowly tailored court order today. The narrowly tailored court order would basically say from the Ramsey County District Court judge that the 2016 Secretary of State Election Judges Guide at pages 14 and 15 entitle ineligible persons to vote. And so we're asking the court to enjoin election judges throughout the state of Minnesota to not provide a ballot to these ineligible persons on the precinct roster. Very narrowly tailored, very simple. Now, how we got here is quite a long story. About 5 months ago in June, we filed a petition with the Minnesota Supreme Court, an errors and omissions petition. It was delivered to the Secretary of State. So there have been 5 months for the Secretary of State to correct this error, this imprecision in his election judge guide, but he's failed to do so. And so today we're in court, and we're going to get a court order where the judge tells election judges, no longer in Minnesota are we going to give ballots to ineligible voters. Now you might say, how big a problem is this? Well, we looked, and we've been looking at who's voting while designated ineligible on the precinct rosters. And every time that it was crossed out, felony challenge citizenship, challenge guardianship, we found that it was an ineligible voter, not an eligible voter. We never found one instance where an eligible person was marked ineligible, which is great. Everyone agrees that no eligible person should be marked ineligible on the roster. In fact, the Secretary of State, through Gary Poser, the Minnesota Director of Elections, has said these people are double, triple vetted. That's fantastic. That means that all people marked on the precinct roster, according to the election guide, you're supposed to give them a ballot, but they're ineligible. So we're only talking about stopping ineligible people from voting. That's good. That's what the law requires. The Minnesota statutes involved in this case, particularly Minnesota Statute 204C12, are good statutes. Our legislature has passed good statutes. 204C12 is a good statute that allows challenges of eligibility based on residency and so forth. It's not a way to allow ineligible people to vote. That exceeds the authority of the Secretary of State. We're not challenging statutes. We're challenging the 2016 Election Judge Guide, which requires an election judge to give a ballot to an ineligible voter. Mr. Poser, in an email sent out to election judges November 2nd, indicated that 204C12 requires him to tell the election judges to give ballots to ineligible voters. That's hogwash. The 2016 Election Judge Guide goes beyond 204C12 and exceeds the Secretary of State's authority. It's illegal. So the reason why we have hundreds and hundreds and hundreds of convictions of felons voting is because the Secretary of State has an illegal policy that requires election judges to give ineligible felons ballots. The plain meaning of 204C12 provides for only new challenges on election day based on personal knowledge. Anyone would read 204C12, you would see that it's a chance for someone who knows that someone's marked eligible is ineligible. So a voter comes and say, as personal knowledge, they can challenge on election day that a person is ineligible. Prior to the election, there are ample opportunities for people who are marked ineligible to change it to eligibility if the documents show that. For example, the Secretary of State receives information from the court system and from the Department of Corrections regarding ineligible felons. They're marked challenged. So prior to the election, an ineligible felon can go to the Department of Corrections, can go to the court, and can change a mistake. The people who end up marked as ineligible on the precinct roster on election day are those people who have not exercised those challenges. So why would the 2016 election guide indicate give them a ballot if they self-certify verbally that they're eligible? This isn't loving your neighbor, facilitating through the election judge guide felonies by felons. You have violations of probation orders, you have violations of their parole. It's all bad. We don't want felonious voting in Minnesota. Stop the felonies, and the only way to do that is to stop the election judge guide. The election judge guide is a written policy that violates 204C12. Allowing people already to turn ineligible is an absurd result. Imagine, these are felons. They're ineligible to vote, and we're allowing them to self-certify their eligibility verbally? No. They have to go back to court, go back to the court administrator, go back to the Department of Corrections and get it fixed. The Secretary of State, through Gary Poser's November 2nd document, has admitted many things that are important to note. First, he admitted that basically by his silence, that the Department of Corrections, Minnesota court system, and Department Motor Vehicle reports on felons, wards, and non-citizens are accurate. Prior in the litigation, they were saying, oh, it's the other state agency's fault. But in the context of this litigation, they've abandoned that argument. When you see a shape changer like that, you know there's an element of dishonesty. Now they're saying we get accurate reports, but there might be some errors downstream. So that contradicts the fact that everyone knows there's double or triple vetting. There isn't one historical incident, not one, where someone has come forward and said, I was eligible and marked ineligible on the roster. Not a one. And you would think with this policy in place for many years, more than 5 years, that would be the case. Finally, the jurisdiction exists in the Ramsey County District Court to resolve this dispute. It's really sad that the Secretary of State and these election official managers are saying, we don't need oversight. We don't need judicial oversight. I'm a lawyer. I'm telling you that when the courts hold the government accountable to law, it redeems the system. It's not a bad thing. It's a good thing when election officials are held accountable to election law. And so today, we hope that the court says yes, under the process of a common law writ of quo warranto, or a statutory Chapter 586 writ of mandamus, or under the Chapter 555 declaratory judgment action, or the Minnesota's election contest statute, the errors and omissions statute, Minnesota 204B.44. Somewhere in there, there's jurisdiction. You know why I know that? It's because on September 28th, the Minnesota Supreme Court issued a unanimous, per curiam, that means everyone co-authored it, published opinion which said this errors and omissions petition, the exact same issues we're dealing with today, should be heard in district court first. So why would the Minnesota Supreme Court publish a decision saying you should go get your remedies in district court if there weren't jurisdiction here? After all, we're talking about the government. The Minnesota Supreme Court is part of the government. Ramsey County District Court is part of the government. The Secretary of State is part of the government. So where do we get our judicial oversight? We get it here and we get it today. Thank you.
You're asking for
Any further questions?
Do you believe that it's reasonable for the judge to rule on this today?
Yes, because there are several instances, even this past week, in the November 2 memo, where Mr. Poser, the Minnesota Director of Elections, sent an email out changing the procedures at the polling place. Previously, Mary Kiffmeyer, per an affidavit, sent out on the day of election a new way to handle, with respect to proving residency, cell phone bills. And there are other examples where, and another example would be the Secretary of State issued a policy a couple days before the election, I believe it was 2012, regarding election day apparel, what's allowed to be worn, what's not. And so there's several instances where changes have been made on election day or right previous to election day, and this would be one of those cases. We don't want this to seep into post-election challenges. There are going to be close elections, and we don't want this issue to come up. So we're trying to prevent a harm, because everyone agrees that ineligible people shouldn't be allowed to vote.
You're asking for a change in the current election.
Yes, we're asking for a change before November 8th.
Which is part, 1,000, how many thousand people have already voted?
But this is different because those people are vetted. We're talking about the precinct rosters, and the election judge guide applies to the precinct rosters. So this involves the election judges. It's a different issue. It's a very narrowly tailored. It's just one issue, and that is the election judge guide requires an election ballot to be given on election day by the election judge to an ineligible person.
Do you have any idea how many ineligible felons there are on the roster now?
All the people given ballots under this policy have been ineligible.
Do you have any idea how many?
If there is one, it is too many. And we would have a better answer for that question, and it's a very good question. We'd have a very good answer for that if the Secretary of State would release the data to us, which he's refused to do.
How long ago did you ask for that data?
That was some number of years ago, 3 years?
Several times, most recently in 2015. And with respect to the answer to the question, we set our volunteers and hired staff on that question. We went through the court records to see if these people who were given ballots as they're ineligible, if any of them were eligible. And we found 1,700 instances of this, and every voter who voted, was given a ballot under this policy, was ineligible. So there has been one person found 1,700 times. Not one of those persons was eligible.
Do you have that record? Do you have that data?
Yeah, it's been submitted to the court, and it's found. In fact, the margin of victory in the Coleman-Franken race, there were 700, I think, ineligible felons we found, and the margin of victory was 312 votes.
So you're going to be submitting that data to the courts?
That's right. Then I think one of the bigger issues is regarding non-citizens. If you look at page 14 of the Election Judges Guide, it has these categories: challenged felony. And can you believe it? On the challenged felony, it says they may have committed a felony. No, they're ineligible. Under challenged guardianship, they may be under court order. No, they're ineligible. And then under citizenship, they couldn't even do that. See how clever this is? Because when these people are identified on their motor vehicle license, the driver's license, as status update, status challenge, they're noted as ineligible from the Department of Motor Vehicles to the Secretary of State. But they couldn't be challenged citizenship, but that's actually what's on the roster. But they couldn't describe it on page 14 because they never had the right to vote. But yet the question on page 15 is, are you a citizen? So in Minnesota, on election day registration, if you're a non-citizen and you go in and you say I'm a citizen, your vote counts. And then they tell us, oh, that can be challenged later through prosecution. No, the vote counts because we don't have provisional ballots.
Do you disagree with Justice Anderson's comments in the paper yesterday? Supreme Court Justice Anderson?
Yes, I disagree with him, because if you want to have the best election system in the world, you have to work at it. And here, you have to have judicial accountability to work at it. And so we found this huge hole, and we told the Secretary of State in June, there's a huge problem here, in that your policy actually tells the election judges to provide ballots to ineligible persons. And we've got all the evidence, all the documents. It all lays out fine, and we should get our order today. And the great thing about the order is it's a beginning of a process to have a better election system. There's no anti-government point here. We're just trying to get a court order to get this part fixed. And of course, there are many other parts that need to be fixed. But this Election Judge Guide, 2016 Election Judge Guide, is in error because it exceeds the authority of 204C12. Now, I want to tell you this. This is not an example of me being a good lawyer. 300 election judges have contacted me through signing this petition, and it's the election judges that brought the issue. This is a big problem. These arguments are accessible. The election judges know this. There's not one election judge, not one, who has come forward with an affidavit supporting the Secretary of State. So do you go with the 3 election judges, or do you go with 0? I mean, zero election judges would agree with this, because if I sat down with them, and they've already know it, they would agree with me.
You mean the 300?
No, everyone would agree. No one's going to disagree that you can't have ineligible persons vote. I would ask anyone in the crowd to say, who thinks ineligible people should vote? No one thinks ineligible people should vote, yet this policy actually requires the election judges to allow ineligible persons to vote. So basically, Mr. Justice Anderson, I really admire him. And he's right, but he would agree with me that it's a long, arduous process to keep a good election system. And there can be mistakes made, mutual mistakes made. People can intentionally deviate from the standard. I don't know. But here, we're starting today to get a better election system.
Just to clarify something from earlier, it sounds as though this is not resolved today. You're ready and prepared to pounce on any recount situation post-election to bolster this argument?
Well, the argument, in a sense, isn't new. Coleman raised it through his attorneys. Emmer raised it through his attorneys. Local candidates in close elections have raised it through their attorneys. But the problem is the ineligible person's votes are already counted. They can't be clawed back. And so now what we're going to do is, at least we pre-election have done everything we can do, and post-election we'll deal with the post-election contests. And then further, this litigation itself will continue beyond the election to clean it up for 2018.
Is the state arguing that this court has no jurisdiction in this case?
Yes, the Secretary of State is arguing, like King George, that they're immune from lawsuits. And so they're basically saying we're immune from all lawsuits in district court. We don't want no judicial oversight. And so we've responded by arguing the 4 possible bases for jurisdiction. And then what we've done is we should point out that the September 28, 2016 Minnesota Supreme Court case pointed us to district court and suggested that it had jurisdiction. Of course, we have to respect the district court, but the district court has the Supreme Court opinion, and I think the district court will find it has jurisdiction, because we need judicial oversight, not only over all state officials, including the Secretary of State.
What do you think about the Secretary of State threatening the election judges with being fired or criminal charges being brought against them?
Well, that's wrong. When there's an issue like this, the Secretary of State should sit down, just like these 300 election judges, and say, oh, I should change the policy. Rather, he's doubled down, tripled down, quadrupled down, and now he's saying he's going to dismiss these election judges or maybe prosecute them. And I think it would have been better for him to do his homework.
Well, he's saying that they have to execute the oath to follow the policy, otherwise they can't be a judge. As far as I know, he's not dismissing anyone.
And the oath requires the election judges to follow
State
Minnesota
law.
Yes.
State law.
And we believe that the Secretary of State's election judge guide is in violation of Minnesota election law.
So basically what it comes down to, one way to summarize it, is the Secretary of State can't mean it, that if his policy leads to the commission of felonies, that we have to participate in that system. And so it's a felony to vote while you're ineligible, and his policy requires the election judge to give ineligible persons ballots, which is a felony. So
we believe that the judge is going to rule in our favor, and the peril for any election judges is really minimal. Eric, I'm stepping out a little bit beyond my authority here, but I think it's that threat of dismissal is a little bit of puffery, because the head judge can always reassign the judge to hand out I voted stickers.
It's just fascinating. Here's what needs to happen. Now, I did research on felon votings, and in Ramsey County alone, I had about 129. I'd have to go check my numbers again. Felons that voted. What was really amazing that there was one felon who voted, got convicted of a misdemeanor for voting, went out, still a felon, and voted again. Now, I don't know that anything's happened. There wasn't anything in the records to show that they were charging this individual again. But what's happening is felons are voting. And these election judges are allowing them to vote because of what Secretary of State Steve Simon is telling the election judges to do, which is contrary to the Minnesota Constitution and the statutes. So what needs to happen is pressure needs to be put on the Republican House, the leaders in the Republican House and the Republican Senate, to have Steve Simon come to the committees and answer questions. And they need to subpoena him. If he doesn't come voluntarily, they need to subpoena him and say, hey, you know, they need to grill down and ask questions. Why did you allow this felon to vote? And they need to make him sweat. You know, I don't know if they're going to do this, but this is the type of pressure that needs to be done. Steve Simon should be impeached. He's knowingly, willingly violating the Constitution of Minnesota, making sure that illegal felons can vote. All you have to do is just go in and swear, I'm not a felon. You know, oh, guess what? You get a vote. Hey, anybody here, if you're an illegal alien, I'm a U.S. citizen. If you're under guardianship, I'm not under guardianship. You know, they have the script, you know, just swear this oath that you're none of these things and you get to vote. You know, 700 felons in the Franken-Coleman race voted. Unfortunately, we know that most of those are DFL or would have voted for Franken. And in the survey of, you know, Ramsey County did convict some of these people in a survey there. Well, you don't know if they're telling the truth, but the overall majority of these felons that voted, that were convicted in conversations, said they voted for the Democrat senator. So, I mean, that changed everything. That's why we have Obamacare, because that gave the 60th senator the vote. Well, we're running out of time. Upcoming shows, we're going to really dig in locally what's happening with radical Muslims or Muslim Brotherhood or the whole Muslim Somali affairs that are taking place in Minnesota. So hope you watch in the future. Thanks for watching. We'll see you later.